What would you expect happens if a piece of national legislation contradicts EU law? And what would you expect the remedy should be if this contradiction negatively affects the rights of an individual engaged in litigation before a national court? What would you intuitively imagine the algorithm should be for affected individuals to defend their rights under EU law against contradicting national legislation? These are the matters which we will be discussing. Simplistically, the affected individual is expected to take one simple step: ask the national court to apply EU law and refuse to apply national law. However, for a number of reasons, either justifiably or not, the quote-unquote chain of national courts reviewing the particular case, think court of first instance, court of second instance, etc., might hypothetically refuse to or fail to apply EU law and apply national law instead, thereby potentially violating EU law. The remedy against this is the right of the affected individual to seek damages from the state for the violation of EU law, either committed by the national court or permitted by the national court's refusal or failure to apply EU law. Intuitively, people might often expect that if national courts refuse to apply EU law, then affected individuals should be able to turn directly to the Court of Justice of the European Union for protection of rights under EU law. But, somewhat unintuitively, that is not the case. The right to damages is actually also exercised before national courts, either before different chambers of the same courts of that chain, or before another type of courts in the respective court system of the member state in question. So, in practical terms, what happens can be boiled down in broad strokes as follows. You invoke EU law before the national courts. The national courts refuse or fail to apply EU law. You pursue state liability for damages caused by the courts, and you do that either before the same court or before a different type of courts in the member state. That second chain of courts now rules on the question: did the previous chain of courts violate EU law, and did that result in damages for this person? To be clear, the first case, before the first chain of courts, resolves a dispute between persons A and B. On the other hand, the second chain of litigation does not affect the rights proclaimed, created, or removed through the final judgment in the first chain of litigation. So, whatever person B got at the end of the first litigation chain remains as the court decided. The second chain of litigation is between person A and the state for damages caused by the courts, person B being no party to the proceedings, and person B's rights not being affected by the outcome of the second chain of litigation. But what happens if this second chain of courts ultimately also does not apply EU law, either refuses to or fails to, or perhaps applies it incorrectly? Well, in that case, the same remedy is prescribed. You pursue state liability for damages caused by the second chain of courts before the respective court in the member state, which now becomes a third chain of litigation. That third chain of courts now rules on the question: did an element in the second chain of courts violate EU law by not finding that an element in the first chain of courts failed to comply with EU law, and did that result in damages for this person? But what happens if this third chain of courts ultimately also refuses to apply EU law? Well, the same algorithm applies again and again. Some observers may comment that this system displays certain imperfections. For example, the system permits for judges in one court to adjudicate on the matter of whether other judges from either the same court or from another court of the same member state caused state liability for damages. which could be seen as being close to a situation where the guilty are trying themselves. One conclusion which can be drawn from this is that this system hypothetically allows for a situation where the affected person, despite having rights under EU law, despite those rights being violated due to contradicting national law, may practically find themselves in a position where they cannot directly achieve effective protection of these rights by national courts, if said national courts are truly determined for whatever reason to uphold national law at the expense of EU law. Now, one observation which could be made is that the current system makes the independence, professionalism, and commitment of national courts to EU law exceptionally crucial for the preservation of rights under EU law. It follows that any threat to the independence or professionalism of national courts also constitutes a threat to rights under EU law. Therefore, one practical conclusion which can be derived from this is that if you or your company are relying directly on EU law for rights which seem to be endangered by national legislation, then you might be best advised to explore the specific reasons why national legislation was created or permitted to exist contradicting EU law, and whether the court's professionalism or independence may need to be supported in some way in light of these reasons. Therefore, your strategy may have to rely not solely on good legal counsel, but may also require the inclusion of other elements to facilitate a higher degree of insulation of the professionalism or independence of the court from any political factors which may have been among the reasons for the existence of national legislation contradicting EU law. These elements may or may not include issuing pleas to the national court for the filing of requests for a preliminary ruling by the national court to the European Court of Justice if applicable, or drawing the attention of the European Commission to the existence of national legislation contradicting EU legislation, or employing class action lawsuits if available in the respective jurisdiction, or potentially turning for assistance to your embassy if you or your company hail from another member state, or, in some scenarios, bringing the matter to the attention of the media if the occasion justifiably calls for it. Now, as you may imagine, the described algorithm conceals a number of other intricacies. For example, to what extent does EU law permit you to rely directly on it in your particular case? Did the national courts violate EU law in a sufficiently serious manner? What constitutes sufficient seriousness? Which element of EU law does national legislation contradict? The treaties, or an EU legislative act, or a delegated or an implementing act? Is it a directive or a regulation? Could the directive have direct effect in the particular case? Was the other party in the initial litigation chain also the state? For example, a national regulatory body, perhaps? How exactly did the national court fail to apply EU law? Did it apply it incorrectly? Or did it misinterpret EU law? Or did it incorrectly find that EU law was not applicable in the particular case? What was the particular reasoning of the court in the initial chain of litigation? What are the constitutional, statutory, and doctrinal rights of each of the courts? These and many more issues can be relevant, but we obviously do not have the time to go into each one of them. That being said, it is hoped that now you have a somewhat basic understanding about the main elements of the standard algorithm in case a national court fails or refuses to apply EU law in a case where national legislation contradicts EU law. Thank you for your time and good luck.